In today's interconnected economy, understanding international business law has become essential for companies operating across borders. With £3.7 trillion in UK legal services exports in 2024 alone, Britain stands at the forefront of global legal expertise. Navigating over 200 distinct legal jurisdictions worldwide presents significant challenges, yet also opportunities for well-prepared businesses. English law governs approximately 40% of global corporate arbitrations, highlighting its continued relevance in international commerce. As 77% of businesses face cross-border legal challenges, mastering the principles of international business law has never been more crucial for commercial success in the global marketplace. International business law encompasses the rules, conventions, treaties and practices that govern commercial relationships and transactions that cross national borders. It serves as a critical framework for resolving disputes, protecting investments, and facilitating trade in the global marketplace. Since the founding of the International Chamber of Commerce in 1919, international business law has evolved significantly. Post-World War II institutions created foundational frameworks still relevant today, while recent decades have seen rapid development responding to globalization and technological change. Unlike domestic legal systems, international business law operates without a central authority, instead relying on cooperation between states. It combines elements of both private law and public international law, making it a unique and complex field. With annual global cross-border trade reaching £4.2 trillion in 2024, international business law provides the essential legal framework that makes this commerce possible and reduces risks for businesses. Legal certainty in cross-border transactions reduces costs by an average of 28%, creating significant savings for businesses engaged in international trade while encouraging further investment. As 67% of UK businesses are engaged in international trade, understanding legal frameworks helps mitigate risks, protect investments, and ensure effective dispute resolution. With regulatory compliance costs averaging 5.7% of revenue, effective legal strategies can significantly improve a company's bottom line while preventing costly disputes. International business law is derived from various sources, including treaties and conventions, customary international law, model laws, and soft law. Treaties like the Convention on International Sale of Goods, CISG, and the New York Convention establish binding frameworks for cross-border commercial activities, creating predictability for businesses. Model laws from organizations like UN-CITRAL and UNIDROIT offer templates for national legislation, promoting harmonization across jurisdictions. Soft law instruments such as ICC Incoterms and FIDIC contracts provide standard terms that facilitate international trade even without formal statutes. The international business law landscape is shaped by key players such as international courts and tribunals, arbitration institutions, international organizations, and national courts. The International Court of Justice, ICJ, resolves disputes between states, while the WTO dispute settlement body addresses trade disagreements. These institutions establish precedents that shape global business operations. Organizations like the London Court of International Arbitration, LCIA, International Chamber of Commerce, ICC, and Singapore International Arbitration Centre provide forums for resolving commercial disputes globally. The World Trade Organization, UN Commission on International Trade Law, UN-CITRAL, and Organization for Economic Cooperation and Development, OECD, develop rules, standards, and best practices that govern international business transactions. National courts in global financial centres like London, New York, and Singapore frequently handle cases with international elements, creating jurisprudence that influences business practices worldwide. Global legal frameworks in international trade are interconnected, providing a complex but navigable system for international business. The World Trade Organization provides fundamental rules for global trade, while thousands of bilateral investment treaties offer more targeted protections for cross-border investments. Regional frameworks like EU trade agreements establish deeper integration in specific geographical areas, often going beyond WTO commitments. The New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards serves as a crucial tool for dispute resolution, ensuring that arbitration decisions across national boundaries are enforceable. Contract law across borders is essential for international commerce, with English law remaining particularly popular for its predictability and flexibility. Countries representing 78% of world trade have ratified the UN Convention on Contracts for the International Sale of Goods, CISG, providing a uniform framework that bridges common law and civil law approaches, though parties may modify or exclude its provisions. Choice of law clauses are essential in international contracts, with 92% of contracts containing explicit choice of law clauses to provide certainty. Even with clear governing laws, businesses must consider how local laws may impact their agreements. Effective dispute resolution is crucial for international business transactions. Arbitration has become the preferred mechanism for many cross-border disputes due to its flexibility, neutrality, and the relative ease of enforcing awards under the New York Convention. Traditional litigation offers a familiar process, but can be time-consuming, which courts have bypassed through mediation, parallel proceedings, and enforcing foreign judgments. The Singapore Convention on Mediation represents a growing trend toward more collaborative resolution methods, while tactical considerations around forum shopping and anti-suit injunctions add layers of complexity to international disputes. Investment protection is a key concern for international businesses, with over 2,800 bilateral investment treaties worldwide providing reciprocal obligations between states to protect foreign investors from unfair treatment, arbitrary measures, and uncompensated expropriation of assets. The ICSID has handled 848 cases since 1966, with £14.3 billion in awards, demonstrating the importance of investor-state dispute settlement mechanisms. Fair and equitable treatment provisions require states to maintain stable regulatory environments, while expropriation protections ensure investors receive prompt and adequate compensation for nationalised assets. The World Trade Organization forms the cornerstone of the multilateral trading system, with 164 member states covering 98% of global trade. Since the GATT's creation in 1947, average tariffs have fallen dramatically from 40% to just 5% today, facilitating unprecedented growth in international commerce. The WTO's dispute settlement system has resolved 600 trade disputes since 1995, providing a rules-based approach to managing trade conflicts. Key principles, including most favored nation treatment, prevent discrimination between trading partners and national treatment requiring imported goods to be treated equally to domestic products, underpin the entire system, creating a more predictable environment for international businesses. Intellectual property protection presents unique challenges in international business due to its territorial nature. The TRIPS Agreement, Trade-Related Aspects of Intellectual Property Rights, establishes minimum protection standards for WTO members, covering patents, trademarks, and copyrights. With 3.3 million patent applications filed globally each year, and 13.7 million active trademark registrations, protecting intellectual property across multiple jurisdictions remains particularly difficult, requiring coordinated strategies, including customs measures, border seizures, and litigation in multiple countries to effectively combat counterfeiting and infringement. Competition law poses significant challenges for international businesses due to overlapping and sometimes conflicting requirements across jurisdictions. With the European Union imposing £8.7 billion in fines over the past 5 years, major merger control authorities reviewing over 2,800 transactions annually, competition compliance has become a top priority for multinational firms. The extraterritorial application of competition laws means businesses can face enforcement actions from multiple authorities for the same conduct. Effective compliance programs, however, can save companies approximately 40% in potential penalties while reducing the risk of private damages, claims that often follow regulatory findings of anti-competitive behaviour. Multinational enterprises face complex decisions regarding corporate structure, operating in an average of 43 countries and navigating disparate legal regimes. These structures must balance tax efficiency, liability protection, governance requirements, and operational flexibility across multiple jurisdictions. With foreign direct investment totaling £1.2 trillion in 2024, businesses must carefully consider entity types, capital structures, and governance models that comply with varying local requirements. Corporate social responsibility and ESG, environmental, social governance standards, have become increasingly important, with many jurisdictions now mandating disclosures and due diligence procedures. Beneficial ownership transparency regulations in major economies have created new compliance challenges, requiring businesses to track and disclose corporate ownership chains while managing privacy concerns and addressing regulatory requirements. Taxation in international business presents unique challenges, with the OECD-led 15% global minimum tax impacting over 10,000 multinational enterprises, aimed at preventing profit shifting to low-tax jurisdictions and ensuring companies pay a fair share in countries where they generate profit. With £3 billion under examination in transfer pricing disputes, companies must carefully document and justify prices charged in transactions between related entities to demonstrate compliance with the arm's length principle. More than 3,000 bilateral double taxation agreements help prevent the same income being taxed twice in different countries, allocating taxing rights between jurisdictions and providing mechanisms to resolve disputes. Digital services taxes implemented in 27 jurisdictions represent another challenge, targeting profits derived from digital business models that operate within minimal physical presence, creating new compliance challenges for technology companies. The landmark case of Apple versus Samsung demonstrates the challenges of enforcing intellectual property rights across multiple jurisdictions. Apple filed its lawsuit in 2011, alleging Samsung's smartphones and tablets infringe multiple patents and trade dress rights. In 2012, the US jury awarded Apple $1 billion in damages, later reduced by the court. Parallel litigation continues in Germany, UK, Netherlands, South Korea, Japan, and Australia. By 2014, settlement of non-US cases allowed companies to pursue American cases. After 7 years of litigation across 11 jurisdictions and $4.3 billion in damages and legal costs, the companies reached a final settlement in 2018. This case highlights the territorial nature of IP rights and the strategic importance of forum selection in international disputes. The Yukos versus Russia case illustrates the complexities of international investment disputes. Once Russia's largest oil company, Yukos was selectively nationalized through expropriation between 2003-2007, prompting the largest arbitration award ever. A tribunal in The Hague made history by awarding Yukos shareholders approximately $50 billion, the largest arbitration award ever. The tribunal found Russia had conducted an unlawful expropriation of Yukos's assets. Despite the record award, enforcement challenges have faced extraordinary difficulty in securing assets abroad due to sovereign immunity defences. Courts in multiple jurisdictions issued contradictory rulings on enforcement, highlighting the complex intersection of investment law and state sovereignty. After multiple appeals, set-asides and reinstatements, the case continues in various jurisdictions more than 15 years after its initial expropriation, demonstrating the practical challenges of enforcing investment treaty awards against resistant sovereigns. The landmark cases involving Google highlight the European Commission's aggressive enforcement approach and the extraterritorial reach of EU competition law. The Commission's $2.4 billion fine for Google Shopping 2017 required implementation of equal treatment principle for rival comparison services. Google Android 2018 faced a $4.3 billion fine for restrictive clauses in AdSense contracts, preventing website owners from placing competing search ads. The Commission's $1.5 billion fine for Google AdSense 2019 addressed similar issues. These cases forced global business model changes despite Google being a US company, demonstrating the Brussels effect, where EU regulations influence corporate behaviour worldwide. Brexit created unprecedented legal challenges for businesses engaged in the £294 billion UK-EU trade relationship. The end of the Brussels regulation significantly impacts cross-border litigation, creating uncertainty around the recognition and enforcement of judgments between the UK and EU member states, despite the UK's accession to the Lugano Convention. For businesses, changes to applicable law on cross-border contracts require careful consideration, with many businesses seeking choice of law clauses to mitigate alternative arrangements like the Hague Service Convention. Changes to applicable law on cross-border contracts require careful consideration, with many businesses seeking choice of law clauses to mitigate alternative arrangements like the Hague Service Convention. Changes to applicable law on cross-border contracts require careful consideration, with many businesses seeking choice of law clauses to mitigate alternative arrangements like the Hague Service Convention. International sanctions present unique challenges for multinational businesses navigating conflicting legal requirements. BNP Paribas's record, $8.9 billion fine for US sanctions violations, demonstrates the consequences of non-compliance, while cases like Huawei illustrate how sanctions compliance can be a key issue for global operations. International sanctions often conflict with laws issued when one country's sanctions prohibit transactions that another jurisdiction requires or permits. The EU blocking statute, for example, prohibits EU companies from complying with US sanctions against Iran, creating seemingly irreconcilable obligations. Compliance programs must therefore adopt sophisticated risk-based approaches, with enhanced due diligence for high-risk jurisdictions and regular screening against constantly evolving sanctions lists. The digital transformation of international business law is reshaping the legal landscape, with smart contracts automating cross-border transactions worth over £2 billion, reducing the need for intermediaries. Virtual dispute resolution has accelerated the digitization of legal proceedings, with 95% of international arbitrations now conducted virtually. This shift has reduced costs and increased efficiency while raising new questions about procedural fairness and evidence presentation. AI-powered legal tools are revolutionizing compliance monitoring, risk assessment, and due diligence, providing valuable resources for multinational businesses navigating multiple legal regimes. Climate change and ESG regulations are reshaping the business landscape, with mandatory climate reporting requirements in 32 countries urging businesses to assess and disclose climate-related financial risks and emissions data. Supply chain due diligence is becoming crucial, as 18 major economies require companies to identify and manage human rights risks throughout their global supply chains. Carbon border adjustments are affecting trade, with mechanisms impacting 75Bs in trade to increase carbon pricing on imports to prevent carbon leakage and protect local industries. Climate litigation is on the rise, with over 2,000 cases filed globally seeking to hold governments and companies accountable for environmental commitments. These regulations present a rapidly evolving landscape of legal requirements for businesses, demanding sophisticated data collection and reporting systems. The global privacy landscape is being shaped by the EU's General Data Protection Regulation, influencing 128 national privacy laws worldwide. This regulation creates a complex patchwork of requirements for businesses handling personal data across borders. Cross-border data flows are valued at £8.3 trillion annually, with increasing regulatory barriers. Data localization requirements in major markets like China, Russia, and India require companies to navigate divergent approaches to data management. Transfer mechanisms, including adequacy decisions and standard contractual clauses, are vital for ensuring compliance with global frameworks. Digital trade agreements, such as the Digital Economy Partnership Agreement, establish rules for digital trade, including electronic contracts, online consumer protection, and paperless trading. Artificial intelligence governance is becoming increasingly important, with the EU AI Act categorizing AI systems based on risk levels and imposing transparency requirements. Over 45 countries are developing AI governance frameworks, creating a complex patchwork of regulations. Businesses deploying AI across borders must navigate divergent approaches to risk assessment, transparency, and accountability. Liability regimes are evolving, with new questions around foreseeability, causation, and the allocation of responsibility among developers, deployers, and users of autonomous systems. Compliance strategies are essential, incorporating risk assessment methodologies, documentation requirements, testing protocols, and oversight mechanisms to ensure compliance across jurisdictions. Future trends in international business law are focusing on digital trade harmonization, with 87 jurisdictions working to align digital trade rules. These efforts aim to reduce regulatory fragmentation and improve cross-border digital commerce. International commercial courts, like those in Singapore and Dubai, are gaining prominence, offering specialized forums for resolving complex international disputes. These hybrid institutions combine elements of common law and civil law traditions, providing efficient and effective dispute resolution. Evolving dispute resolution mechanisms are prioritizing efficiency and commercial outcomes over rigid procedural frameworks, offering flexible alternatives that emphasize resolving disputes through negotiation and mediation. Key takeaways from this presentation highlight the importance of proactive risk management, with businesses implementing comprehensive legal risk assessment and management programs, saving an average of 31% in costs compared to those that respond reactively to international legal challenges. Strategic forum selection is crucial, as carefully choosing where and how to resolve disputes impacts outcomes in 74% of cases. Compliance by design is essential. Integrating legal compliance into business processes from the outset reduces violations by 65% compared to bolt-on compliance programs. Specialist expertise is vital, as the complexity of international business law necessitates specific advice tailored to specific jurisdictions and sectors. Engaging appropriate expertise early in transaction planning can prevent costly complications and maximize strategic advantages.